Straight ahead on Law and Crime Daily. A friend to accused Kenosha killer Kyle Rittenhouse is himself under arrest on firearms charges related to a deadly shooting amid racial tensions.
A court hearing for Britney Spears as she seeks to end her father's control over her finances. And Tiger King Joe Exotic takes his plea for a pardon to social media.
Also,
my father died a hero, trying to save a family he didn't even know.
The family of a repairman who became one of the victims in a triple murder speaks to the jury. Will it be life in prison or death for the defendant, Brandon Willie Martin? Law and Crime Daily covers court cases from coast to coast.
And welcome to Law and Crime Daily, everybody. I'm Aaron Keller, along with Buckmire Terri Austin. Let's begin in the Midwest, where authorities have filed charges against Dominic Black, an 18-year-old they say supplied the gun used by friend Kyle Rittenhouse to shoot and kill 2 people during protests in Kenosha, Wisconsin over the summer. The Milwaukee Journal-Sentinel reports that Black told investigators he drove almost clear across the state of Wisconsin to purchase the Smith & Wesson M&P 15 rifle Rittenhouse used. Black was old enough to buy the gun, and authorities say he signed paperwork saying he was buying it for himself. Rittenhouse, who is 17, was not old enough to make the purchase. Brian and Terry are here right off the top tonight to discuss this development. So, Terry, my understanding is that this gun purchase is called a straw purchase. How does liability attach to Black when Rittenhouse was the one who pulled the trigger?
Well, anytime you have a straw purchase, it's when one person buys a gun for someone who's either unwilling or unable to buy the gun. Here, Rittenhouse couldn't buy the gun because he was underage. So Black could be liable because, one, he either knew what Rittenhouse was going to do or because Rittenhouse was underage. And we know already that Rittenhouse was underage. So he definitely has some exposure here.
Okay, so Brian, give us some insight into what Black's defense strategy might be in this case.
This is going to be difficult, Aaron, because really it doesn't matter what you know or believe the person receiving that gun to do, so long as you intentionally give them that gun. And the harsh part here is if they either kill themselves or someone else, it jumps up to what's called an H-class felony, 6 years in jail. I think you've got to lean into this case and you say, hey, Kyle Rittenhouse is a hero, and this is a person who provided him with the tools to do so. Otherwise, I don't see a win here.
So in other words, the defense strategy may be connected to what Kyle Rittenhouse is saying through his attorneys, Terry, and that is that I acted in self-defense and I was there to defend other people's property. A lot of people don't buy that, but that's right. Rittenhouse's defense strategy.
That's right. I mean, if that's in fact what they prevail on, the fact that this was a defense, then you can't associate Black with knowing he was going to, quote unquote, use it for a crime. But I still fall back on the fact that he was underage, so that could still be some exposure.
I mean, the core facts themselves may be the prosecutor's ultimate best argument in this case. So, Terry, you also have an update on the ongoing legal battle involving pop star Britney Spears for us.
Well, that's right. Spears is letting a judge know her relationship with her father is toxic, and she wants him removed as her conservator. The pop star first had a conservator, also known as a guardian, appointed in 2008 when she was struggling with mental health problems. Her father, James Spears, and an attorney ran the conservatorship for 11 years. The attorney stepped down in August of this year, and Spears said in court documents that she strongly objects to her father controlling her $60 million in assets. James Spears says he's done his job well, taking the estate from being in debt to being profitable. Attorneys for both sides are arguing the matter in a virtual hearing that is closed to the public.
Thanks a lot, Terry. Dina is an attorney in California, joining us specially now. Dina, is 11 years an unusually long time for a conservator to oversee someone else's financial affairs?
Her conservatorship is very unusual because usually it's only done for somebody who has severe mental incapacity, somebody who's unable to care for themselves. It's true that she had, in the beginning of this, mental health problems, but since then we have seen her perform in Las Vegas, et cetera. So for it to go on for this long when she is able to kind of conduct her life is unusual.
So, Terry, Britney Spears at one point asked for a corporate fiduciary named Bessemer Trust to oversee her affairs. And the court even believes that a conservator should remain here. So why a company and not a relative?
So what I think she's trying to do is get a trust that will be objective. She's looking for someone who's not related to her. Someone who's related to her might actually have some biases and might be trying to influence and is really, if you think about it, self-interested. So I think it does make sense for her to find a corporation with an objective purpose in running the estate.
Excellent point, Terry. Now, Brian, is it time, as they say, to free Britney?
Short answer is yes. And as I'm looking at this now, Britney Spears has the ability to articulate who she wants to guide her finances and her personal issues with, and who she doesn't. She doesn't seem to have an inability to understand how to take care of herself or to perform or make money. I don't see what the argument is here. She just doesn't want her father to take care of her affairs.
Okay, so Dina, any guess as to why this case required a closed-door hearing? Because it was happening and we couldn't listen and we couldn't see it.
Well, for one thing, her father, Jamie Spears, has requested all along that these proceedings be so private, he said, because the revealing of the information would be harmful to her and her children. But in this last filing, her court-appointed attorney is asking for more transparency in the hearings. So hopefully we will start to see that. I mean, she seems to actually be sympathetic to her own Free Britney movement and wants the public to hear more about what's going on here.
Oh, certainly. I mean, if the movement's going to help, then why not latch onto it? And Dina, finally for you as well, is it time to free Britney in your legal opinion?
In my legal opinion, I would say yes, but I'm hedging it with because we have not had access to these hearings. We don't really know the evidence that's being presented for the continuing of this. We're only seeing what she's doing in public. And in public, like I said, I mean, she had these multi-day tour in Las Vegas, which you would think somebody with mental, physical capacity could only do that tour. So like I said, we don't have all the facts, but it does seem like she is doing better and would be able to start taking care of herself.
Good insight, Dina Dahl. Thanks for joining, especially from California on the broadcast. A Colorado judge has declared a mistrial because of the coronavirus in the case of a man accused of killing his son. Prosecutors say Mark Redwine killed 13-year-old Dylan in 2012. Investigators think the victim found so-called compromising photos of his father, and that may have been the motive. Jury selection began, but ultimately stopped when the judge thought he had COVID-19 symptoms. He tested negative, but then the defense said they too needed to quarantine because of possible symptoms. The lead prosecutor accused the defense of intentionally trying to delay the trial. The court granted the mistrial because on the basis of ineffective assistance of counsel. And still ahead here on Law and Crime Daily, voters in California making major changes to a major prosecutor's office, all in the name of justice reform. And later on, you remember this guy, right? The Tiger King? He's making a last-ditch legal effort to win the attention of the president. Let's turn once again now to a number of criminal justice reform measures which appeared on the 2020 election ballot. Brian Buckmire, you recently talked with advocates about what some of the voters' decisions mean.
Yeah, Aaron, so I had the opportunity to speak with Emily Galvin-Almanza, who is the founder and CEO of Partners for Justice. Here are some of my conversation with her this week about the decisions at the ballot box and what they mean. Let's look a little bit more at California, because there are two big things that were also on the ballot box there that got voted into. First, it had to do with the DA's prosecution rates in LA. And then second, the idea of abolishing mandatory staffing in San Francisco, not abolishing the police altogether, but just this concept of mandatory staffing. Starting with LA, can you kind of walk us through what California is doing in terms of police reform?
Absolutely. So we talked about San Diego before. San Diego, 75% or more of voters voting in favor of a civilian review board. Huge, because San Diego County, as you know, is not a lefty county. It's a pretty conservative county. So you're seeing conservative movement on policing. Just north in LA, you're seeing a DA's race that was in many ways a referendum on incumbent DA's Jackie Lacey's failure to prosecute police. The LAPD and the LA Sheriff's Department have had astonishing, like cinematic level police violence problems, including a gang, a criminal gang within the Sheriff's Department. We're talking police officers who have been accused of, getting tattoos for people that they kill. So really, really frightening police misconduct problems in LA County. Jackie Lacey does not have a history of prosecuting bad cops. That was something Black Lives Matter LA had really, really been protesting, was Jackie Lacey's total failure to hold police accountable. Now, George Gascon, the newly elected DA, was elected on a reform ticket. He's promised not only to hold police accountable, but to utilize other tools that increase police accountability, like, for example, refusing to call known lying police as witnesses in his cases and refusing to rely on gang database information that it has been shown to be dramatically flawed. So you've got a new DA who said, I'm not going to trust the cops who lie. I'm not going to trust the information we know is false. And I'm definitely going to hold bad cops accountable. He beat the incumbent DA in what was a pretty astonishing thumping. She had originally been endorsed by many key California politicos. They all rolled back their endorsements as Gascon gained popularity. So I think in many ways that race was a referendum on her choices regarding policing and a demand from the people of LA to increase accountability for police. Now, up north in San Francisco, this may sound like a really boring measure, but it's actually really exciting. So in San Francisco, there was a minimum staffing requirement. A little less than 2,000 cops had to be on the force at all times. The measure that was passed removed that minimum staffing requirement and basically said, we only need to hire as many cops as we actually need, which, when you take a step back, sounds pretty reasonable. We don't have minimum staffing requirements for other positions. The city may grow or shrink. Like, why would we have this floor for police? Because police unions negotiate well is why we have that. But what's great about it is, in a world where cities are turning to more effective, more evidence-based alternatives, utilizing social workers and healthcare workers, and juvenile specialists in areas where they may be safer and more effective than using a police officer, it's really hard to allocate the funding for that if you're stuck having this minimum legion of police that you don't actually need. So what this measure does is give San Francisco the freedom to hire people who might be better at these actual tasks than the police they have on the force.
All right. Well, we'll see how this plays out for San Francisco as well as LA County. It appears that the ballot box is where the people have spoken and that this is what they want going forward. Emily, always a pleasure having you on. Thank you very much.
Thanks again, Brian.
Thanks a lot, Brian. And when we return here on Law and Crime Daily, a sheriff who handled the investigation into an infamous Ohio massacre of 8 people returns to court for his own legal troubles. And Tiger King's Joe Exotic makes yet another plea to get out of federal prison. A legal plea from Joe Exotic from the Netflix series Tiger King, plus a sheriff whose department investigated Ohio's infamous Pike County massacre, is basically pleading for leniency in his own legal troubles. Law and Crime's Angenette Levy has been following developments in those cases for us. Angenette?
Yeah, Aaron, Pike County Sheriff Charlie Reeder, you'll recall that he's been suspended for more than a year. He pleaded guilty to charges related to the theft of drug money seized during investigations by his sheriff's office. Now, the charges include 2 counts of theft in office and 2 counts of tampering with evidence. Reeder now wants those charges combined since he says they're similar and that could reduce his prison sentence. Prosecutors say the counts should stand individually since there were 4 separate offenses related to 4 different evidence bags filled with money. The judge has not yet ruled on the motion. Reeder faces at least 9 years in prison when he's sentenced in January. Joe Exotic, the star of the Netflix docuseries Tiger King, says he now has evidence that would have helped him defend himself at trial. He says that evidence was kept from him by his public defenders. His real name, of course, is Joseph Maldonado Passage. He was convicted in federal court of several wildlife violations related to euthanizing and illegally selling tiger cubs in violation of the Endangered Species Act. He was also convicted of trying to hire someone to kill a competitor. In an Instagram post, Maldonado Passage said he now has binders with reports from the USDA that state he was allowed to euthanize tigers using gunshots. He tagged President Trump in the post and said the laws need to be changed. He also wants President Trump to issue a pardon for him. Maldonado Passage is currently serving a 22-year prison sentence. One of his appeals has already been denied. Aaron, back to you.
Thanks, Angenette. And so, Terry, how many publicity stunts is Joe Exotic going to try? He had a bus caravan going to the White House, and now he's taken to social media.
I think he's going to try as many publicity stunts as he can until he tries to get this, overturned or a pardon. So, in fact, he was convicted. One of the convictions was for, shooting 5 of these tigers in the head to make room for other tigers. And if, in fact, this Instagram post says that there's evidence to say one agency said it was okay to shoot these tigers in the head, then he is going to try to get anybody to listen. And he tagged the president to get the president to listen. So I think he's going to keep going and do as much as he possibly can, even though he is still obviously in jail.
Ever a showman using unofficial channels this time. So, Brian, what's the likelihood that he could successfully snag a pardon, or should he really be worrying about filing some ineffective assistance of counsel claims?
Yeah, so what he's arguing about the binder that the public defender had and didn't use evidence that would have cleared him, that sounds like a pretty clear ineffective assistance of counsel, and he probably should go that route. I understand him trying to go for the pardon for President Trump, but the likelihood of getting that is slim to none, I would say, as the clock is ticking 70 days and a few hours and counting before there could be a new president. I don't think that President Trump is focused on this case. He might be focused on others.
Yeah, so the legal argument is what we really need to focus on here. I've got a binder, my attorneys didn't use it, and they should have used it, and therefore, Your Honor, I need relief.
Yeah, I think that's the argument that he should be making. Based on his Instagram post, that seems to be a more clear-cut way of getting this done. I don't think he's going to get the attention of President Trump, and I think the president's focus is on greater things for him.
Yes, Joe Exotic, though, still pressing his case. And when we come back here on Law and Crime Daily, the son of a murdered repairman testifies in the trial of the former baseball player convicted of triple murder. The question now is the punishment. A former pro baseball player is now facing a possible death sentence after a jury convicted him for committing 3 murders. Brandon Willie Martin was found guilty of slugging to death with a baseball bat his father, his uncle, and a security system installation man. The jury must now decide whether Martin should be locked up in prison for the rest of his life or whether he should be executed by the state. The state called the family of Barry Swanson, who was working on the victim's home security system, when prosecutors say he was in the wrong place at the wrong time.
Initially growing up, he was in communications in the computer world. He was in telecommunications. He was a boss. He was a site supervisor and ran projects in the computer industry. And then later on, he switched over into window coverings when I was around, I think, 17, 18. And he had started his own business before getting into the alarms. I built my whole career around it, and I still do it today. With his blessing, he said, he was in Orange County doing it, so I said, can I do it in Riverside? And he goes, yeah, just don't come into my territory. And right. I started my own thing, and now 17 years later, I'm still doing it.
How old was your dad when he was murdered on September the 17th, 2015?
He was 62.
Okay. Was he looking to retire?
Yes, he only had just a few weeks left and was going to be just living with my family and I and enjoying his retirement and taking care of the grandkids.
Martin had been released from a mental health institution before committing the crimes. On cross, the defense asked the victim's son if he believes the institution bears responsibility for the murders.
Not for his actions, not for what he did.
Do you believe that they bear some responsibility in this case?
I think their responsibility is opposite of what his responsibility is. I don't think that it's relevant, honestly, in my mind.
There is a lawsuit pending against the County of Riverside and the Regional Center, correct?
I'm not allowed to comment on that.
Is there a pending lawsuit?
Yes.
Okay, and you're part of that lawsuit, correct?
That's public record, but I'm not allowed to talk about it. It is pending until he is found guilty. He has been found guilty.
The defense asked the victim's son if he had ever received correspondence from the defendant's mother, who was not at home when those killings occurred.
I was never approached. I was handed a letter by her nephew, Michael Anderson.
Okay. And did you have a chance to look at that letter?
I looked at it before I threw it in the trash.
And was that essentially a condolences or apology letter from her?
She apologized for what her son had done, and I believe from what I read in it, I only read it the one time before I threw it away, and I was very emotional, but I believe it was that she apologized for the actions of her son, and she felt he needed to be punished for what he did. I believe that's what the letter was entailed to. I don't have a copy of it, but what I read was that he deserved to be punished for what he did, and she was very sorry for what her son did to my father.
Terry, what do you make of the trashing of the letter? I'm wondering how it's relevant to the ultimate question of life or death here.
It's not relevant to that question, but what it does show is that the victim's son is very emotional, and he should be. I mean, his father was in the wrong place at the wrong time, and he was murdered. So it's a very horrendous situation. And in fact, at the end of the day, this defendant is either going to get, life or death. And frankly, because of the mental issues, I think ultimately he will probably get life in a mental institution, or at least he should be getting some sort of treatment.
I agree with the treatment. The question as to the punishment, I'll leave to the jury, myself at least personally. Terry, you're allowed to have your own opinions. Brian, let's talk about the questions about that mental health institution, because I thought the defense had every right to inquire into that, and the witness was stalling it for some reason.
Yes and no. So can you ask about ongoing litigation? Sure, you can, but I'm not sure if this is the right witness, both from a strategy standpoint and also a relevance standpoint, to get into. I think they can do that through other routes. Defense attorneys, myself included, are guilty of doing this a lot of time, and that's shutting their mouths. This could have been a situation where the defense just shut their mouth and said, I don't think this is the witness to question, because there is no one in this world who doesn't have sympathy for that witness, and they should have just walked away.
Yeah, I was going to say as well, Brian, I agree with that. This may not have been the right witness for it. You have to handle a cross-examination like that very delicately. I'm not sure the right tone was struck. We're out of time here on Law and Crime Daily. We certainly appreciate you joining us. We'll see you next time for our discussions here about justice in America.